And then at the end, I'm gonna leave it on this, and this is just what you do to end it, okay?
Oh, you want me to end it?
You're live, and then this is all you need to do. Just hit the X button, and just exit out of all of it, okay?
You don't have to do anything on that.
No, you don't have to do anything on this. You don't need to touch this at all.
Okay, I know Neil did at the planning commission meeting, so I didn't know.
Yeah, no, no need to touch that. You'll just, yeah, so you can just keep this here, and then you can just exit out of here, and then it'll exit out of the Zoom as well in there.
Say it again.
Mayor Elkins is here too, so
Okay.
I think he'll be okay. Can you end this whenever it's done? Can you end that whenever it's done? We're live. Okay.
Okay. All right, we'll go ahead and call the Board of Zoning Appeals meeting to order. But please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right. We'll go ahead with the roll call. Todd Humbert, I'm present. Dave Ship. Here. Primo Nino,
Yeah.
Ronald Mundi.
Here.
And vacant seat. Has everybody had a chance to look over the minutes?
Yes.
Yes. All right, do I have a motion to approve the minutes?
Go ahead, approve it. I'll second it.
All right. All in favor, say aye.
Aye.
Aye. Any opposed? All right, minutes approved. And I guess next thing up, be up to you, Phil.
That's fine. Just for the record, my name is Phil Schneider. I'm the city attorney for the city of Huntingburg, and this is a hearing of Crossvine Solar LLC's appeal of, before the Board of Zoning Appeals. I'll be representing the Board of Zoning Appeals in the procedural aspects of this hearing. The parties are represented by different counsel, separate counsel, and they'll introduce themselves a little later. But this is Crossvine Solar One LLC of the City of Huntingburg Zoning Administrators Administrative Determination dated December 2, 2025 regarding the following issues. First of all, the determination that Crossvine's Commercial Solar Energy System Development Plan approval expired by operation of the city's Unified Development Ordinance, UDO, for failure to obtain all the applicable permits and commence construction within 2 years after approval. Now, the other issue is the implementation by the administrator of the November 25, 2025 Huntingburg Common Council legislative directive declaring a moratorium on the consideration of any new, revised, or resubmitted development plans for commercial solar energy systems pending the Plan Commission and the council's opportunity to review and revise and update development standards. So the BZA's role tonight is to listen to the relevant evidence, the testimony, and review the evidence that's presented at this hearing and determine whether or not the zoning administrator correctly applied the relevant provisions of the UDO regarding the expiration of the development plan, and whether or not he correctly implemented the council's legislative directive declaring a moratorium on the consideration of new, revised, or resubmitted commercial solar development plans. The order of presentation tonight will be, of course, the petitioner Crossvine will proceed first, present their case. The Huntingburg Zoning Administrator will then present its case. There'll be an opportunity for public comment. The petitioner appellant Crossvine will then have an opportunity to any rebuttal if they feel it necessary. And then the zoning administrator will have an opportunity to do cross rebuttal. And finally, the board will undertake deliberation and a decision. Before we get too far along, I do want to recommend that the board adopt some rules for public comment. This is a public meeting and it is a hearing, and the statutes that govern Board of Zoning Appeals hearings do permit members of the public to present relevant evidence. And however, you may, within reason, adopt rules to make sure that the record is not overburdened with too much comment, too much redundant and irrelevant comment. So I would recommend, in fact, I think I've got somewhere here, some recommended rules. Just pass those down. For the public portion of it, what I'm recommending is that, of course, each speaker needs to approach the podium and identify themselves by name and address. Second of all, I would recommend that you limit all public comments to 3 minutes per speaker. The comments must be factually relevant to the issues presented for the appeal. There's 2 issues. The expiration of the development plan and the moratorium implementation. There be no repetitious comments by the members of the public. We don't want to keep repeating the same issues. And there'd be no comments regarding the general merits or adverse impacts of the project in general, unless they directly impact or are related to one of those 2 issues. And then finally, the chair would reserve the right to interrupt any comments that are contrary to those rules. If those rules are acceptable to the Board of Zoning Appeals, I would suggest that you approve those or adopt those by motion.
And approve those. I'll
I'll
make a
sec-
motion to approve it.
I'll second the motion.
Okay.
All in favor?
Aye.
Aye. All opposed? None opposed. All right.
So at this time, why don't we let the parties' counsel introduce themselves, starting with Crossvine, the petitioner.
Thank you. My name is Douglas Everett. I'm here on behalf of Crossvine. I'm an attorney at Denton's. My address is 2700 Market Tower, 10 West Market Street, Indianapolis, Indiana.
Thank you. You may have to go to the
You
podium.
have to turn the sound down. We can't hear.
nothing back here.
Oh.
We don't, I don't know if they have speakers out there on that side.
There's a green light on it.
Mm.
Hello. Well, for the record, I'll yell. My name is Joshua Claiborne. I'm with the law firm of Jackson Kelly PLLC. I'm here on behalf of the city of Huntingburg and the zoning administrator, Mr. Paul Lake.
So with those introductions, if the petitioner appellant would like to proceed.
We would. Thank you. Good evening. Thank you for having us. We have quite a few important issues to discuss tonight. In front of you are copies of all the critical exhibits that we've introduced into the record for you to review.
Dusty.
Do you hear that?
Testing. Testing.
Can you hear me?
Can you hear it in there, Paul?
Yeah, I can. Can you hear me?
What's that?
Didn't hear nobody.
Can you hear me?
Yes.
I can hear you.
Okay. This is designed to go through the feed, not through the speaker up here, so.
Well, presenters will have to speak up.
I will. Thank you. I won't, if I'm yelling, it's not because I'm mad or upset. I'm just speaking out loud, okay? So we've given the board several exhibits. I have them listed on this here. We have what, 25 exhibits that we prepared for you to review. all those were tendered on March 6th. I want to talk about the objections here. There's just three that I will have, that I want on the record as, and these are the three that I don't want to repeat every time. So if we hear something, I don't want to have to interrupt and make these. So I just want to say this applies to this proceeding, you know, lack of impartiality. We don't want people to talk about solar is great. You don't want to hear, that's not what this is about. Or I wish we had more batteries in this area. This is not about those issues. This is really a procedural matter, whether we comply with the UDO requirements or not. And Phil's already mentioned about excluding redundant, immaterial, and irrelevant testimony. Let's go to the next slide. So tonight, this really is a very narrow issue. The only question is whether the dismissal of our development plan was valid. So let's look at the UDO, which is our guide. This is also in Exhibit 15. The UDO says that approval of a development plan shall be valid for 2 years from the date of the administrator's approval if all applicable permits and construction has not commenced. We're going to start with construction. Has construction commenced? The concept of commencement of construction is not discussed in the city's administrative notice of approval or in the development plan at all. The phrase is not defined in the UDO. So what does it mean to commence construction? Well, it depends on the type of construction that's involved. We all know, we've seen home builders, they pour foundations, they put up exterior walls. For wetland and drainage, those types of projects, there's a lot of moving dirt. They're not going to be putting in footers or putting up walls. That type of construction activities is different, and they have different standards for commencing construction for those different types of projects. I have a case here in Indiana, actually a citation to the Fire Safety Building and Equipment Law, which actually defined construction. It means the following: fabrication of any part of an industrialized building system or mobile structure for use at another site. It doesn't say it has to be on the site. It just says they fabricate it for use on another site. So even in Indiana code, they recognize the construction can occur off-site. So what does commencing construction mean in the solar industry? Well, we don't have to look very far because we're in a county that has already decided what commencing construction means. Dubois County, their engineer has already decided that this project has already commenced construction. And without saying what's obvious, but I will, you know, the city of Huntingburg is in the county. Okay, so we don't have to look or guess, you know, what other states do, how they interpret commencing construction. We have it right here, and it's for this very project. So what is commencing construction? Like I said, off-site pre-assembly. In our case, you're doing racking, you're working on your solar modules, battery modules, control enclosures, your main transformer. All of that is occurring off-site. We don't want to have a crew here for 4 years putting in bolts to make each panel. It's disruptive to the public. It creates a lot of noise, dust, traffic. A lot of these panels are constructed and assembled off-site. So far, my client has spent over $75 million in procuring and conducting off-site assembly and other activities. As some of you may have seen, there is a MET station that has been installed. It's not in the city's jurisdiction, it's in the county, but that's used for the overall project. And somebody can talk about why there's a MET station and why it's important for the project. But I want to make clear that this project is not an abandoned project. They have continuously and actively engaged in the process of construction, even if you don't see an ILP filed, which then would lead to bulldozers and other types of construction activities that you may be used to seeing with other types of construction. For this project, if we don't meet the IRS standards for commencing construction, and there's a definition in the federal code for that, this project could lose $125 million just for this project. This is the amount of money we're talking about here. For starting construction, they have to prove to the federal government, in order to get this kind of money, that they've commenced construction. And so there, you can imagine there's a lot of requirements for that. They didn't set these standards. A lot of this comes from the Biden administration and other administrations that have decided for national policy purpose, they wanted to have renewable resources. So my client and the solar industry and overall, when you're looking at that much of a tax benefit just for this project, this size, which is about 300 or so million CapEx in total, they follow what the IRS rules are. What does it mean to construct? Because if they don't follow those rules, this is the kind of money they would lose. And it's significant. So there's a safe harbor compliance related to that. I'll talk about that later. But let's go to the next slide. So just like the difference in commencing construction for home building, as I mentioned, or wetland or drainage construction, solar has its own standards. And it's not just my client, it's the solar industry. So the question is, when a zoning administrator is analyzing whether a developer has commenced construction, would it need to consider the type of industry and the type of development project to guide its decision-making? Yes. Not every project needs an ILP. They don't, because they all have different construction standards. They may just need grading, and so they wouldn't even need an ILP. But for some reason, the planning administrator decided to say we didn't comply, we didn't start construction. And one of the reasons is we didn't have an ILP. That was just evidence, and that was not evidence at all. So let me go to the next slide. Oh, thank you. This one here. Okay, thank you. The administrator's December 2nd letter says, it does not appear that any construction has commenced. It doesn't say you guys didn't construct. It doesn't appear you did. They don't even say we didn't construct. It doesn't appear. But that was one of the reasons why they denied or they dismissed our development plan that was filed. So if you looked at the site, you would not be able to see all the offsite work, obviously. But even the text of the UDO does not state that on-site physical work is required. And Crossvine describes all of its construction activities in the materials that's presented, and we're going to have the company representative come up and go through those materials. We're not going to go through all of those pages, okay? This not necessary. And it'll be a short testimony. They're not going to take a lot of time here. So the best way for the BZA to determine whether construction has commenced is look at the local standards. Who is ruled on this locally, and that's the county. The county has already determined they've had enough evidence that they've given them to make the determination that they have constructed. And then look what's in the solar industry overall. What is the industry view as constructed? And they really don't have a choice. They can certainly get an ILP and start constructing. That's one of the standards. But the other standard is off-site. And I'll talk about that in a little bit. So the UDO also talks about you need all applicable permits as well. So that's all it says. And you can see, well, maybe you can on the slide, but it says well, I won't turn around. I'll read this way. Approval of a development plan shall be valid for 2 years from the date of the administrator's approval if all applicable permits and construction. So all applicable permits, you need to have that too. But the administrator's letter doesn't say all applicable permits. It starts talking about what permits they think we need. In fact, it says there has been no application for ILP or any of the state mandated permits required for the ILP. Their sole focus was ILP. Statute doesn't say ILP. It says all applicable permits. So the UDO does not reference any specific permit like an ILP or related permits, state mandated or otherwise. The UDO does not reference needing all permits to complete construction. It doesn't say you need all of it. You don't need your building. You don't need your electrical permit. It doesn't say anything like that. And so we believe it's self-evident, but I'll say it. The December letter inappropriately rewrites the language of the UDO, and instead of applicable permit, identifies the permits that it thinks is required in order for Crossvine to commence construction. What is an ILP? Some of you may not know, it's basically just a building permit. And I have a citation in the UDO. It's for the erection, alteration, or a modification of structures. That's what an ILP. But and we look at another section here, and ILP is not necessarily required for landscape, vegetation, utility installations, local services, drainage installations, certain structures less than 50 feet. There's a lot of things ILP is not required for. So the administrator's rationale and assumption that the UDO requires Crossvine to apply for an ILP, that's flatly wrong. An ILP is not required by the UDO, even though Crossvine has commenced construction. It's not required. They haven't taken on site the physical actions to build or construct something that they're not at that phase yet. They're constructing everything off site. Commencement of construction in the solar industry, as I mentioned, means on-site work or compliance with the solar safe harbors and a demonstration of ongoing development activities. Even Dubois County knows this. That's why they said that we've commenced construction. And at this early stage in construction, the ILP and other permits required to get the ILP are just not required. They're not required yet. So Crossvine has complied with everything necessary to timely meet the 2-year time frame. Now, I'm going to let one of the company representatives come up, and they're going to walk you through all the things that they have done off-site to show that they've commenced construction, and it's significant. They'll also talk about the IURC, which regulates this project as well. As you may or may not know, the Indiana Utility Regulatory Commission regulates electric utilities, but they also regulate independent power producers like this project that are producing power. Before my client can construct on a project, they have to go to the IURC to get authorization to commence construction. So we have not only the state regulations, but we have the local regulations to comply. And they've done that. They have what's called a certificate of convenience, or CPCN. They've received that. I'll let them speak more about that. But there's other guidelines and conditions for constructing, and that was one of the permits that they needed. And they obviously have that. So with that, could you come up here and speak? Just introduce yourself, your name and your address. And then when he's done speaking, I'll continue. Thank you.
Yeah, my name is Jose de Souza. I work for AES Indiana, and my address is 1 Monument Circle, 46204, Indianapolis, Indiana. So we wanted to show you kind of the timeline for the project since the moment AES Indiana acquired the project. As most of you know, we bought this project from a previous developer. Lightsource VP was developing this project. And as part of that acquisition, before making any work on the project, AES Indiana needed, as Council was explaining, needed to get a certificate of public convenience and necessity approved by the IURC. That basically allows the utility to and shows that that project will have a positive impact on the customer rates for AES Indiana and for the customers from AES Indiana. And based on that certificate, the company is allowed to recover investments over that a generation project that gets approved. That approval happened in April 2025. Right after that, we met the conditions that were required to buy the project to the previous developer, that was Lightsource VP, and the purchase was completed in May 2025. So after that process, with kind of the investment approved from the IURC, the company was able to enter into all the agreements that were required for the project to keep going on the construction work. So as I said, the acquisition happened in May, and in July, by July, we have had all the agreements for main equipment already negotiated and signed with the different suppliers, and that kick off construction and production of those parts. I want to make a statement here, and I mean, solar projects, most of these projects have long lead items that usually takes more than a year to get into the queues and then to produce or be assembled. So the way these projects are, and that's kind of the rationale why the IRS admits or has as part of the ways to demonstrate the start of construction, the safe harbor provision. The safe harbor provision establishes that once you have committed and you have paid, and that's kind of the trigger for the 5% of the total project investment, and in this case, the total project investment is over 300 million. In this case, after we have surpassed that amount of invoices paid to the different equipment providers, we are getting into the safe harbor condition and meeting the definition for start of construction for this project that happened on July 16, 2025. And the way it happened was by, as I said, we signed all the agreements for our equipment, and as part of the evidence, you have the invoices for our modules that started production right after we signed our agreements, and the invoices for those agreements are part of the evidence that was provided. On top of those, other components of the project were also starting construction, particularly not in this jurisdiction, but batteries were also starting construction and being assembled because they need to be assembled inside the enclosures, and that happened outside the is happening on Utah right now, but that's out of the jurisdiction for this area. And also we started all the site surveys that were needed for informed engineering. At risk, the company had done 30% design, which is also a part of designing the project. And when I say at risk, is because that portion of the project the company did it before getting approval. But right after that, we started all our site activities for surveys like geotech, underground utility survey. We also started our drain tile survey, and all those inform details on the engineering needed to get to 60% design and 90% design, which is at the end, the 90% design is the minimum level that you need to get to be able to provide the ILP submission, because it needs to get to more informed engineering level. So that's how the project has been working since then. We currently have all our engineering ready. We currently have all our state permits for even for SWEP already granted and reviewed by the states, and we have the information available to continue the ILP to prepare to mobilization. Will be the next stage of the project. As I said before, and was also mentioning, currently the project, the total investment for the project is over 300 millions. The project expense up to date is over 125 millions. And by the moment that the August 7th date, the investment was over 75 millions. I think that will be, yes. Sorry.
So let me just stop here, do a little bit of a summary. That was a lot of information. So Crossvine commenced construction within 2 years after its development plan was approved and is in full compliance with the UDO. Crossvine has all applicable permits required by the UDO, and the administrator's determinations were wrong and must be reversed. The city's position is that the UDO requires Crossvine to commence on-site construction by August 7th. That's just untrue. There's no on-site is not the rule. It doesn't say on-site. Nowhere in our UDO does it say on-site. That is not in the rule. That's made up. The city's position is the IRS beginning of construction is irrelevant. That's completely untrue. The standards in the solar industry for beginning construction are physical work commenced either on-site or off-site, or as Jose mentioned, paid or incurred 5% or more of the total cost of the facility. And I can show you where those are in there, but we do have those in there, and they were paid in advance of the deadline for commencing construction. And then we have to continue to make continuous efforts to advance towards completion of the facility. That's called the safe harbor test. The city's position is that the county's engineer determination that Crossvine commenced should have no weight. Well, that's completely untrue. Why would you not look to this community for determination as, I don't know, we don't have it in our code as how to define it. How did the county do it? I mean, we are in the county. Well, we know how they did it. The city's position, they cited one of our cases, which we use for another purpose, but they said that vested rights does not arise without going ahead with construction. That shows, on-site construction, and that's required to commence construction. You need to have on-site construction to get vested rights. That's untrue as well. The case that they cited was a case that relied on facts and circumstances and a judge's interpretation of what construction meant and for vested rights purposes in 2005. The Indiana legislature got tired of having 500 EPC contractors and other companies come before them every day because one town said you didn't commence construction because you didn't move enough dirt or some other thing. And it filled the courts up with, did you commence construction? When did you do it? So what did the State House do? They created a new law. The new law is in Indiana, and this was after this case, it was 2006. You don't have to commence construction at all. We don't care whether you started construction. That is out of the statute. It says what you need to do is you need to submit a completed permit application, a complete application. In this case, it's our development plan, but it could be a building permit. And once you submit that application on that date, even before it's even ruled as valid or not, you have vested rights. That's the code that in Indiana now, nothing about whether you constructed, it's whether you submitted a valid permit. So that's why the city's position on commencing construction is not true. City's position is because the ILP is a required permit, Crossvine must obtain it by the time they need it to. Well, that's untrue because the UDO language is commence construction and it talks about applicable permits. It doesn't say that you need an ILP. It says you're going to have to get the ones that are applicable for commencing construction. So the administrator's determination that Crossvine did not appear, which is another issue, he didn't even say we didn't start construction. They said it appears you didn't commence construction. That's what he said. That is not evidence that it hasn't. While an ILP certainly is a required permit, it is not needed to commence construction. The city's position is that Crossvine's primary evidence of commencement are its bills of lading, which is in Exhibit 24. That is untrue. That exhibit, all that was, is it shows that we have continuing efforts to advance towards completion. We have to do that in order to preserve our $125 million credits from the federal government. That's why it's in there. The second reason why it's in there is because it was given to provide the county context as to what we've spent. It showed the off-site activities. We have exhibits in there that shows that we spent money to meet the 5% test, and I can show you exactly where those are, but it certainly wasn't that exhibit. The administrator cannot rely on an obviously unenforceable moratorium as a lawful basis to deny consideration of any new revised or resubmitted development plan. So we're going to the moratorium now. We are going there. So, let me rephrase this. What are the key aspects of unlawful legislative actions? Legislators are required to take steps to repeal text amendments, actions that exceed statutory authority. Legal challenges can be challenged in court. This is when they're unlawful. It subjects the legislative body, in the case of the city, to payment of damages, awards if it fails to repeal what was a purposeful act, but it is illegal. Respectfully, Paul can't just say, I was just following orders. That's my defense. A plan administrator just can't implement a legislative directive when that directive is not a valid legislative act. He couldn't have said something like, you can't look at any permit applications if somebody's over 250 pounds. If they did that, well, it's legislative action. Paul, got to follow that. You don't have to follow that. You don't have to believe, well, he's just following directions. Like as a BZA, our hands are tied. When it's obviously something that's not true, not lawful, you don't have to sit here and do nothing. You can tell Paul, planning administrator, you shouldn't have followed that at all. There's no, and that's why it's no binding effect when it's not valid. It has no binding effect whatsoever. We have a memo in our files that goes through all the legal parameters of how you create a valid moratorium. And we want to put that into the record though. It's full of case law and other citations and arguments. But a moratorium is a quintessential zoning act. We cite the city of Carmel, Martin Marietta, and the citations in there is a 2008 decision. Zoning changes require adoption as an ordinance in conformity with the 600 series. Everybody knows this. I'm not going to go through all the rest of this on this slide here, but we did put a lot of documentation in there for you to look at for support of the position that when you create a moratorium, which is a zoning change, you have to go through the rules to adopt a valid ordinance. That means And I could just have Phil, I could have you testify to this, but he's on video, so you can watch the video. But the process is you go to the Plan Commission and they review it. They open it up to the public, post public input as to whether this ordinance is good or not for the public. Do we want it? They take that into consideration, and then they go back to the county council with their recommendation, and the county council then either adopts it or returns it or rejects it. That's the process. That's under Indiana statute. That's how you create a moratorium. It's not just the common council just sits there one day, someone says, hey, we need a moratorium. And that sounds good. Motion, yep, accept, done. I mean, you can't even find this moratorium on the website if you looked, because it was a moratorium created by motion. So you have to go downtown, you have to go and ask somebody to find it. And it's just written in there, we vote for it. That's it. There's nothing out there. Okay. So we have a public record of an attorney, what he said, that these moratorium, the way it was enacted or created by council was unlawful. It's not valid. He goes through more than a minute to explain to the council that this isn't going to work. We got to do it the right way. I'm not going to play the video. Okay. I'm going to stop there on that point. It's evident. Everybody knows that the moratorium, unfortunately, or fortunately, depends on what side of the equation you're on, was not a valid act. It's not enforceable. It wasn't done the right way under the Indiana law. So when a determination by a planning administrator is based on an obvious fact or circumstance that's totally obviously wrong, the BZA can consider whether the determination itself is invalid. Remember when I said that, oh, you weigh over a certain amount. Well, just following directions. I got to deny your permit because they told me. You don't have to agree with that. The administrator can't rely on obviously unenforceable moratorium either as a lawful basis to deny consideration of or resubmission of development plans. The city's position is nothing to see here. He was just implementing a legislative directive. The BZA has no authority to void a legislative act. Let a court decide. Untrue. First, a legislative act never occurred. You can't do something that isn't even a legislative act if it's something you're not allowed to do in the first place, and you don't even create a legislative act. A directive by the Common Council to its planning administrator to enforce something that was never even a proper legislative act to begin with can't be then used by the planning administrator to effectuate the act. And it's a lot of words there, but it is what it is. So the city provides no evidence that the moratorium has lawful effect. And there is no resolution for the moratorium, as I mentioned. It was just read in as a motion. This is the language behind me. That's the language in the letter. It just says you're notified that, there's no moratorium and we're not going to consider any new or modified, revised, resubmitted development plans for commercial solar energy system. That's what he said. So compliance with an unlawful legislative directive is generally not required, as a law that exceeds, statutory authority. Because the moratorium is unlawful, the moratorium can't usurp my client's legal right for resubmitting a development plan for administrative review under the city's zoning regulations as they existed in June 29th, 2023. So if we want to resubmit a plan, if we want to redo it, if you guys agree, you didn't construct, we want it, okay, fine, we'll resubmit it. The moratorium is not something that could be used to prevent us from doing that, because moratorium isn't lawful. And if you guys don't agree that we commence construction or we don't have our permits, you could so rule, but this moratorium doesn't prevent us from refiling. City's position is Exhibit 14 should be excluded as evidence. This is a Rule 408. I'm just going to read this just to preserve the record. The Rule 408 statement is admissible because the statement that the council clearly expressed their opposition to the project is not evidence of an offer of valuable consideration in settlement of a disputed claim. Bridges v. Metro Media Steakhouse, LP 208 Northeast, 807 Northeast 2nd, 162, and Mayberry v. Indiana Department of Correction. I just wanted to read that into the record. Vested rights. This is the last part of my presentation. Indiana vested rights statute has frozen the zoning regulations existing as they were on June 29th, 2003 for this project for a minimum of 3 years and up to 10 years. We filed a development plan. That means no zoning change applies to us. You can change the zone if you want to, but we're locked in. That's an Indiana statute that creates vested rights for our development plan. It's the city's position that mere filing of a development plan is insufficient unless you have construction to demonstrate that the expiration, you got to have that. They cite this case. Again, vested rights says nothing about construction. They eliminated that requirement. For vested rights for up to 10 years, it's just a submission of your either permit, in this case, a development plan. Has nothing to do with whether we did or we did not construct anything. And as I previously mentioned, the Indiana Vested Rights Statute was enacted after a Pinnacle Media case, and they removed construction requirement whatsoever. When you have vested rights, a moratorium or other zoning change is not applicable and does not require and does not bar the submission of any secondary, additional, or related permits or approvals required from the same local governmental agency with respect to the subject matter of the first permit. And that's how you get vested rights. So our ILP, in fact, the permit itself, they all have vested rights. So all the permits that are associated with this that come later in time, as far as any zoning change, the zoning change don't apply to them. So the new zone, whatever it is, can't be used to evaluate whether an ILP or other permit or even the initial permit is compliant. Finally, the renewal of an expired permit does not terminate vested rights. Assuming that this permit is expired or terminated, that doesn't terminate vested rights either. The vested rights statute contemplates what happens if a permit expires prior to the end of the vested rights period. The vesting rights is not cut off. The vested rights statute provides that a permit application and any subsequent related approvals are to be governed for at least 3 years by the ordinance in effect and applicable to the subject property when the original application was filed. In conclusion, the administrator's determination are wrong and must be reversed. Crossvine commenced construction within 2 years after its development plan was approved and is in full compliance with the UDO. Crossvine has all applicable permits required by the UDO. The administrator cannot rely on an obviously unenforceable moratorium as a lawful basis to deny the consideration of a new or resubmitted development plans if we so choose to do so. And finally, the Indiana vested rights statute has frozen the zoning regulations here existing on June 29, 2023 for a minimum of 3 years and actually up to 10 years. Thank you.
Mr. Eber, do you wish to enter this as evidence?
Yes, thank you. We have submitted electronic copies of all these materials in front of you already. But we brought in physical copies for you. So I would like to introduce all of the paper copies of our exhibits into the record.
We do object to Exhibit 14, and I'm happy to expound on that, but as he's alluded to, we view that as a Rule 408 communication that should not be.
So the objection relates to Exhibit 14, in which there was communication by myself, a city attorney, with Mr. Everett concerning potential negotiated settlement. Generally speaking, evidence of negotiation for settlement are not admissible as evidence. And Mr. Claiborne is objecting to just that exhibit, as I understand. It's up to the board to rule in favor or against admission of that particular exhibit.
Phil, should I respond? Would you like me to respond to that? Because we do, as I discussed, we do have case law that says for the limited purposes, we redacted the part that we thought obviously we needed to. But we're not introducing any evidence about what or who said what during settlement discussions. None of that is being disclosed. We are only highlighting what was said on termination. They said, we're done because city council doesn't like solar and they're never going to agree to settle. That's all we have in the record. That's all it says. That's all it stands for, is that statement. Okay.
I think the exhibit is expressly marked as a Rule 408 settlement communication. I think it needs to be treated outside the evidentiary basis for the merits. I think the decision should rest on the ordinance and the objective record. I might suggest that obviously we can proceed whether it's included or not. Whoever is not the victor here can raise that with the court of law afterwards. But I don't even know to what degree that's going to impact this particular board. I think that's a matter for a subsequent venue to the extent we get there. So I think this is, at this point before this board, a little bit of much ado about nothing. But I do object to it as it relates to the potential for this to end up as an exhibit in a future venue.
So my recommendation to the board would be to consider overruling the objection because it still is a matter, he's preserved the objection. The city administrator has preserved the objection for review if this is subject to judicial review in the future. So overrule the objection and admit the entire exhibit would be my recommendation, but that's your decision.
We just making a motion. Yeah. Do we have a motion to overrule the objection?
I got a second.
Go ahead.
Okay.
All right.
Okay. Go first.
That's all right. All in favor, say aye.
Aye.
All opposed? None opposed.
Objection overruled.
And so Crossvine Solar One LLC hearing packet is admitted into the evidence of the record, or into the record.
I'll turn this way, given our microphone problems. That way people can maybe hear me a little better. As I mentioned earlier, my name is Joshua Claiborne. I'm an attorney with Jackson Kelly PLLC, here representing the city and the administrator. I'm going to start here briefly with some lawyerly things, which is presenting some evidentiary foundations, again, for the record. And then after that, some brief arguments that I think will summarize the issues a little bit more clearly. First, want to go ahead.
Let me raise an objection. I don't understand who he's actually representing. He says he represents the city and the administrator.
The administrator is an employee of the city. I represent the city, correct?
So are you representing, city council, or who? I just don't know who.
We represent the city of Huntingburg as it, which encompasses both the city and its council. It's a fair clarification. I'm not here as a personal representative of the planning and zoning administrator, but he is going to be one of the city's witnesses.
And what about the BZA? Are you representing the BZA?
I think you know that. It was
Well-
announced earlier that Mr. Schneider is
Well, I
representing the
just wanna know
BZA.
if you are too.
No,
Okay,
I think that was already established earlier.
okay. And what about the plan commission? Are you representing the plan commission? I just want to make sure who we all are.
Yes,
Okay,
yes.
thank you.
Okay, witness one is going to be, for us is Mr. Paul Lake, the Huntingburg Planning and Zoning Administrator. I appreciate Mr. Lake being here. I think as many of you in this room know, he is unfortunately dealing with quite a big surgery ahead of him. And so for that reason, his doctors have instructed him to not be around the public, not interact with people. To make matters even worse, he's getting over influenza right on the cusp of this surgery. But he is here in this building and here with us via audio and video. Again, I want to establish some evidentiary stuff first. So, Mr. Lake, if you could please state your name and your position for the record.
Yes, my name is Paul Allen Lake. I'm the Planning and Zoning Administrator and Director for the City of Huntingburg.
Thank you. And how long have you served in that position?
I came on board with the City of Huntingburg in this position in late September of 2014.
Are you familiar with the city's Unified Development Ordinance and with the development plan applications that were submitted to the city?
Yes, I am.
Are you familiar with Crossvine Solar One LLC's commercial solar development plan application and the administrative filing related to it?
Yes, I am.
Okay, did you personally review and keep the records associated with that application in your ordinary course of duties?
Yes, I did.
Okay, Mr. Lake, given your situation, I had previously given to you what is City Exhibit Number 1. I'm going to distribute that now to some of the folks here in this room. Just to make this easy, I'm going to give them to you and hope you get pass them on down. Here, I've got to. And Mr. Lake, do you recognize what that is?
Yes, those are excerpts from the City of Huntingburg's Unified Development Ordinance, Chapter 8.
And then I think portions of Chapter 4 are included with that as well. Is that correct?
That is correct.
Okay. Are these a true and accurate excerpt of the city's Unified Development Ordinance that govern the issues involved in this appeal?
Yes, they are.
Okay. Are these ordinance provisions the ones that you relied on and that governed your review in connection with your December 2nd determination?
That is correct.
Okay. Mr. President, members of the BZA, we would offer this Exhibit 1.
Give the petitioner an opportunity to object, or
No objection.
Okay.
you should rule it admitted.
So you do a motion for it?
No, you just, as a chairman, you could rule that it's admitted.
All right, we would admit this exhibit in the evidence.
Okay, thank you. Mr. Lake, could you identify for the board the key provisions that are there in Exhibit 1?
Yes, one, it is discussing primarily are the development plan procedures, the expiration of the development plan after 2 years if construction has not been commenced or an improvement location permit has been issued, and then the standards that apply to a solar energy standards for accessory and commercial both.
Okay, thank you. Does Chapter 8, and I'm going to specifically focus on subsection D2, provide that a development plan approval becomes void unless all applicable permits have been obtained and construction commenced within 2 years of approval?
That is correct.
And do you view that language as discretionary or mandatory in your reading as administrator?
It is not discretionary. It is
Okay. Thank you, Mr. Lake. Let's move on to what what I have labeled as City Exhibit 2. And again, I know when I arrived here in the building, I set them outside your office, so I've handed that to you already. Do you recognize that exhibit?
Exhibit 2 is the development plan application that was submitted by Crossvine Solar One LLC.
Thank
the
you.
city of
Does that exhibit reflect the date on which the development plan was approved?
Yes, August 7th of 2023.
Okay. Does that exhibit have your initials or otherwise indicate that approval in the date?
Yes, it does, on the first
Okay.
page.
Thank you. Mr. President, I would offer here as the city's exhibit number 2.
We accept the exhibit.
Thank you. Based on exhibit 2, Mr. Lake, what date, well, I guess you've established that, let me say this, let me clarify. What date did you treat as the approval date for purposes of Chapter 8, subsection D2 that we talked about earlier that has the 2-year window
August.
above?
That would have been August 7th of 2023.
Okay, and then based on that date, when did the 2-year period expire?
Would have been August 7th of 2025.
Okay, thank you. I'm going to move on now to City Exhibit 3. And I know members of the board that I think all of these so far we're in Crossvines exhibits too, but I think this makes it clean to nonetheless make sure we get them in the record here. So let's start with this. The exhibit 3 that I've handed you, do you recognize that?
Yes, it is the December certified letter that I sent to Crossvine Solar One and Joseph Steins at AES concerning the revocation of the development plan.
So you prepared and issued that notice?
That is correct.
Okay, and it is a true and accurate copy then of your December 2nd determination that's the subject of this appeal?
Yes, it is.
Okay, Mr. President, I'd offer exhibit 3 into evidence.
All right, we accept the exhibit and the evidence.
Thank you. And you've alluded to this, and I think we all know, but what determination were you making in that exhibit 3?
That the development plan as approved on August 7th of 2023 had expired due to the 2-year window without construction commencement.
Is it accurate to say also because not all applicable permits were obtained?
That is correct.
Okay. As of December 2nd, 2025, had Crossvine obtained an improvement location permit?
No, they had not.
After that date, had Crossvine, or sorry, excuse me, as of that date, as of December 2nd, had Crossvine commenced any permit authorized on-site construction within that 2-year period?
No.
Were those conclusions you just offered based on the file, the materials before you in your role as administrator?
Yes, they are.
Okay. Did you visit the site to personally observe whether any on-site construction had occurred?
Yes, I drove the portion of the project that lies within the city of Huntingburg's extraterritorial zoning jurisdiction, which is the subject of the development plan.
Okay.
I did not see anything.
Okay, thank you, Mr. Lake. In applying Chapter 8, subsections D2, did you understand the phrase "all applicable permits" to include the improvement location permit that's required under the commercial solar permitting scheme?
Yes.
Okay, thank you. Mr. Lake, that's all the questions I have for you right now. Members of the board, I also have here what I'm going to label collectively city exhibits 4 and 5. Okay, Mr. President, 4 and 5 are certified official records of the city of Huntingburg. They've been authenticated here by the certificate of the clerk treasurer. The first one, which is Exhibit 4, is the clerk treasurer's certificate, together with a copy of the minutes from the November 25th meeting of the city council, which were the minutes that approved the council by the council on December 9th. So again, it's the minutes from November 25th and then the minutes from December 9th that approved those minutes. So we would offer Exhibit 4 into evidence.
You accept exhibit 4 in evidence?
No objection, I assume?
Looking at it. No objection.
Okay, thank you. The fifth one here is the likewise, and the clerk treasurer had a certificate accompanying both of those on the front there. It's a copy of the December 23rd moratorium resolution and the minutes of that meeting where those were approved by the council. And then they were subsequently approved on January 13th. We'd offer that into evidence as Exhibit 5.
No objection.
Okay, and finally, and again, I believe this has all been referenced already, but I've got here my last exhibit, which is what I'll call our position paper, labeled number 6. It's a written statement of the position of the city for the appeal. Again, that's more for the record. So with that evidence here, I want to unpack what all of this means and
Same here.
You're offering this. as
oh, I'm
exhibit-
sorry, I apologize. Yes, I'm offering Exhibit 6 into evidence. Objection?
Yeah, no objection.
So we accept it as evidence.
All right, thank you. As we've talked about, this is an administrative appeal. Your task is narrow. It's to decide whether Mr. Paul Lake, the city administrator, correctly applied the governing ordinance and the related city directives to the facts that were before him. It's not your job to decide whether something is constitutional, whether something applies with the statutory code, or attacks on the city council's actions. It's to decide whether the administrator followed the code and the directives that were given to him. What does the record establish? Well, first, it establishes that the development plan was approved on August 7th, 2023, and that under Section 8D2 of that code, it became void unless all applicable permits, that's all applicable permits, had been obtained and construction commenced within 2 years. The record also establishes that Crossvine did not obtain an improvement location permit and did not commence on-site permit authorized construction within that period. Either failure of those is independently fatal to approving their appeal. And on that basis alone, the administrator's December 2nd determination should be affirmed. Let's talk about a few of the related issues that Crossvine's attorney raised. First, was construction commenced? Crossvine's evidence, if you look at it and hear their descriptions, it was off-site engineering, it was procurement, also off-site, manufacturing, off-site, and assembly, also off-site, including bills of lading. They're all there in Exhibit 24 for shipments routed to a Utah facility, not the Indiana project site. And even if Crossvine spent real money on this project, on-site
Objection. Real money.
What is the objection?
Real money, where's your evidence there's been fake money spent? I don't understand why you characterize what was spent over $75 million, which is clearly in the record.
Okay.
Why you
I-
mischaracterize
No,
the evidence?
let me restate what I said again so you can hear it more clearly. I said, even if Crossvine spent real money, that, which by the way was mid-sentence, let me finish my sentence. Even if Crossvine spent real money, that is supply chain activity and warehousing. It's not permit authorized on-site construction on the parcel. And I think 3 points address this issue cleanly. First, zoning ordinances use construction commenced to mean on-site work. The UDO Chapter 8, Section D2 is a land use control ordinance. Its purpose is to ensure development plan approvals are timely acted upon, so the city and neighboring neighbors, landowners, aren't bound indefinitely by stale plans. That's the whole point. Otherwise, without staying on task, these things can draw out for quite a long time. The administrator correctly read construction commenced to require on-site activity under required local permits. Second, in response to this, Crossvine wants to cite things like the IRS code, the fire safety code that applies elsewhere in the United States, or even the county, which is a separate municipal body, to say that beginning of construction standards are different. All of those differing statutes, differing rules, and differing municipalities and jurisdictions are irrelevant. Crossvine's IRS guidance, for instance, carries its own definitions, its own exclusions and policy rationale. Same for the county, which is an entirely different municipal entity. What matters is how Huntingburg addresses it and how the state of Indiana addresses it. That has no bearing on how a municipal city zoning ordinance expiration clause operates. Now let's talk about this case of Pinnacle that Crossvine cites as it relates to vested rights. First, that case, which Crossvine cites, drew a pretty firm line that vested rights do not arise, quote, where no work has been commenced and where only preliminary work has been done without going ahead with the construction of the proposed building. That means that design work, studies, procurement to Utah facilities, those are preliminary activities under Indiana law. Crossvine cited these cases itself, and they don't help it. In response to that, Crossvine then tries to bring up the Indiana Vested Rights Statute, which I'll refer to as Section 1109. That's how a lot of us in this area refer to it. That is a non-retroactivity statute. It doesn't determine when construction commences. It prevents a later zoning change from being applied to a complete application during the statutory vesting window. It does not eliminate express expiration conditions in the ordinance in effect at the time of approval. So I think 2 points make this real clear. First, there was no new zoning law that was applied as it relates to the 2-year obligation. The 2-year obligation was there when they applied. It was there in December. It was there in August. It was there throughout the whole period. That 2-year time frame was never once changed in Section 8D2. Second, again, Section 1109 does not extend elapsed approval past its expiration date. Pinnacle Media, that case, rejects the premise that the mere filing creates a vested rights absent sufficient construction, and their off-site procurement does not clear that bar even under the own authority. Its Utah routed logistics fall short of that. Second, let's move on to the second point that Crossvine has raised. And we've addressed this a little bit, but the all applicable permits condition. Crossvine never applied for an ILP. The city's December 2nd notice was explicit. No ILP application was filed. There were no state mandated permits that are required for an ILP that were ever obtained within that 2-year period. And Crossvine notably does not dispute this. They simply try to state that it's not yet applicable. There's no denying they did not obtain an ILP. Its own papers acknowledge this. It hasn't pursued it. Again, it's simply saying that it doesn't need to yet. That's a policy argument, and there's not an ordinance interpretation. The Chapter 8 D2 requires that all applicable permits be obtained within 2 years. It doesn't say when the developer determines the permit is needed. There is no rolling, there's no phase exception that exists in that text. It says all applicable permits. We have to read that as it's written. Let's move on to the third, where Crossvine wants to talk about what's applicable. Their formal position, again, is that the ILP isn't applicable within the 2-year window because it pertains to later construction stages. The answer here is the same in the letter. The Uniform Development Ordinance, all applicable permits language is a bright line condition, not a developer-controlled timeline. If the ILP is a required permit under the city's commercial solar scheme, which Crossvine admits it is required to do, then it is a required all permit under this section. And it was applicable from the moment the development plan was approved to the one it's granted. Crossvine had 2 full years to obtain it. It did not. In addition, in the alternative, the record shows that before Crossvine sought resubmission, the City Council enacted a moratorium that barred new, revised, or resubmitted commercial solar development plans. The administrator did not have authority to disregard that legislative directive. Whether Crossvine later wants to attack that in court is not a question for this board. Your job is not to decide whether it's constitutional, whether it's statutorily correct. As an administrative matter, it is on the books. It is something that the City Council has passed, has adopted, and the administrator properly complied with it. That provides an independent and an alternative basis to affirm this decision. So the city's request is that you affirm the administrator's December 2nd determination on 2 grounds, really 3 grounds. First, that the development plan expired by operation of the UDO because it did not obtain all applicable permits. Second, because construction was not committed within the required 2-year period. And third, because the Common Council enacted its moratorium and it remained in effect during the time of the denial. Thank you.
At this point, on the agenda, we do permit public comments.
When is the rebuttal?
Well, we let public comment and then rebut.
We can do that, or maybe better is to do the rebuttal now and then have public comment. I'll leave it up to you.
Well, let's get everything out there that you might want to rebut. Does that make sense?
Yeah.
Yeah,
Um,
let's do that.
So, again, I remind if you want to make comments, keep your remarks brief, to the point, make sure they're relevant to the 2 issues that, I believe the 2 issues that the parties agree on would be the expiration of the development approval, the plan development approval, and the moratorium. Those are the 2 issues. We're not here tonight to debate the merits or disadvantages of solar or BESs or anything else. It's whether or not this particular development plan lapsed and became void under the terms of the UDO, and whether the city's moratorium prevents further consideration until the Plan Commission has further opportunity to consider new development plan standards. So with that, I'd ask if you want to make public comment, take the podium, give us your name and address, and keep your comments brief and to the point. No one wants to comment?
Bills, we don't have to open Oh, the public hearing is already open or out?
It's already open. It's,
Okay.
it's a public hearing.
My name is Norma Kryline. I'm a resident of Jasper in DuBois County. I am a pediatrician. Listening to this in terms of trying to have an ongoing relationship with the county, with the city, that's what I saw the biggest fallout. You know, the fact that all of that stuff got dropped shows me that there was no communication with him in a timely fashion. And I think that's evidence that going forward, there are still going to be issues. You know, if I get a medical license, I call to make sure my documents are there. If I've got well, I've never dealt with $175 million, but I deal with human lives. And I make sure my documentation is in, I make sure it's in on time, and I make sure it's received. And I think that I saw several places here where I think that could have been done a lot better. Thank you.
Hi, good evening. I just want to bring up,
Name, please.
oh, sorry, thank you. Holly Bartle Gogol. I'm a resident of Huntingburg, located in the ETJ. I wanted to bring up a poster that was posted at AES Crossvines, November 13th, 2025, public meeting. Sorry, I don't have it was on a big poster board. They had a project timeline development. On that poster board, it said 2026 construction, engineering design, all of those things, grid interconnection approval, all of those things were listed as 2026. After the permits or after the development plan had already become void. So they told us again at the public meeting in November that the construction was not done, the engineering design was not done, the site mobilization was not done, all equipment deliveries were not done. And I'm reading their poster board. Civil works were not done. The substation was not complete. So I just think that's important to note. They've kind of told us that this stuff was not done as well at the public meeting at the Huntingburg Event Center. Another thing I just wanted to bring up, they mentioned the fire code, and it just reminded me of correspondence with the Indiana Department of Homeland Security. They resubmitted this project in December 15th of 2025 for approval. So again, they've resubmitted the project. They've made changes to this. So I just want to ask again for the BZA to understand the points of what's actually happening here, and ask for you to deny the appeal. Thank you.
Hi, I'm Corinne Whitehead. I live at 4481 West, 750 South, Huntingburg, directly straight across from where we are discussing. And not that I sit there and watch the field all day long, 24/7, but I can tell you I have actively stared out my front door at that field for the past 10 years. And within the past 2 years, within the quote timeline, I have seen absolutely zero construction, zero people, anything like that going on or anything like that happening. So in terms of, holding on to the appeal and revoking it, doing that, I ask that you deny them because, yeah, I'm an eyewitness to what is happening straight across from me. So thank you.
Thanks.
Thank you. Anybody else, any comments?
Sorry, it was cut on the wire.
All right, that's okay, all right.
Please don't disrupt this technology. You can't believe how hard it was to get this thing set up.
Hi, I'm Ray Niehaus, 8715 South, 500 West, and I'm kind of in the center of Solar Hill. And listening today, I heard both attorneys bring it up. I thought the city of Huntingburg has done a great job of following up. It was interesting to me, at one point, I heard Crossvine talking about they were doing assembly in Elkhart. Today, I'm hearing about things were sent to Utah, yet Crossvine said things were being done somewhere else, off-site. I believe that's what you said, sir.
Correct.
Well, I'm not sure where your off-site is. You know, and I know we import a lot of stuff. You probably import your equipment, correct?
I'm not gonna talk about.
Well, you do. I mean, it's records. It's out there. So all I want to say is I think the second attorney did a great job. I think Paul Lake did a great job following up. And I think you as a council representing us may need to make a decision and really think about this. This is important for all of us, or else we wouldn't be here. Thank you.
Yes.
I'm Dwayne Peck and I live at 750 South, 400 West. The field right north of my house, I'm going to back up per se. And from the very first meeting that we had in 23, when they first proposed this, from that day, there has not been anybody in that field doing any construction. I just wanted to, because actually it's really affecting my home property.
Jared Harris, live right outside of Huntingburg. As far as the off-site construction, first of all, how do you prove any of that? And the spending of the money, losing that money, we don't care about that. And use that crap somewhere else. Go stick those panels somewhere else that aren't by schools. That would be my suggestion. So that's all I got.
My name's Randy Bartlett. I live at 750 West, 750 South, Huntingburg. It seems to me pretty well cut and dried. They didn't start construction. They don't have the permits. I don't, you know, I'm a country boy. Seems pretty cut and dry to me. They don't have a permit to do construction. Thank you.
Anybody else from the public?
No more comment from the public, then I believe we'd let the petitioner give any rebuttal presentation.
Yes. Thank you. We have hundreds of pages of invoice and documents to demonstrate that we have commenced construction activities offsite. I want to point directly to Exhibit 20. It's an exhibit, and if you could turn into your books there. It's about, I don't know, about 5 or 6 pages in. It's from Longi, Longi. It's in red font.
That's probably, I'd say 8 pages in.
Yeah, maybe it's 8. There's
Looks like this.
maybe it's 8 or 9 pages.
Red, the name Longi is in red.
And somebody from the company can talk a little bit more about this, but what this is is it shows that the modulars, which are the solar panels, how many of them were ordered, have been paid for, what the wattage amounts were, and when this happened. This is dated July 3rd, 2025. You can see who it's to. It's to Crossvine 1. It has delivery terms, has payment terms, there's a contract number, tells you what the goods are. These are the panels that are being constructed. On the next page is another invoice with additional components. We've redacted the actual price. We would need a non-disclosure agreement to actually disclose those figures because they're not publicly available, and we don't want our competitors to see those figures. And we're happy, anything, by the way, that's in these exhibits, if you want to see the redacted versions, we're happy to provide them. There are other things that my client can talk about as to where these things are located, what's going on with them. But the point I want to make is that we have spent, my client has spent a lot of money purchasing different types of equipment. It's being worked on, it's being assembled off-site. And with that, I want to address some of the comments that the city his lawyer has raised. He keeps referring to this Pinnacle Media case about, well, the court looked and determined you didn't do enough activities for construction, so you don't get your right. You haven't constructed. So this permit, unfortunately, it's the vested right statute doesn't protect you because you didn't do enough construction. Sorry. Well, as I mentioned, that case was before the vested rights statute was created, because the vested rights statute eliminated all those court cases. Again, there was no statute then about construction. It was whatever a judge had determined in their view was construction. That's not the law anymore. The law is under vested rights is when you file your application, the filing of the application itself, a complete application. And in this case, it's not just filing. It has been approved. We all know that. That triggers vested rights. Not about construction. There's no precondition at all. So he's mischaracterizing what it means for construction. It's not required for vested rights. That's the first thing. The second thing is he complains or argues, to be more precise, that we needed all applicable permits, and one of those was an ILP. It doesn't say that in the UDO. Where does it say ILP? It doesn't. It says you need all applicable permits. And is it what? Do we need a building permit? Certainly at some point we do. And we have 2 years, but we need to commence construction first. But we got to have the applicable permits to do that. That's what it was saying. Not that you need all applicable permits for the whole project. You need the applicable permits to start commencing construction. We have commenced construction off-site, which is allowable. In fact, the whole solar industry builds this way, off-site, because we don't want to affect the public when we have to bring a panel in and construct it and sitting there for months at a time. It's just inefficient, more truck traffic, more noise, more interruptions to everybody's life. These things are produced off-site, just like when you have a house, you know, build your trusses on site. You've seen the trucks. They have the trusses already built off-site, and they're brought on site and actually constructed. That's the first thing. We don't have an ILP, that's obvious, because we don't need it yet. It's not an applicable permit. What an applicable permit is, and we do have them, is we have authorization from the IURC to even start construction. We had to get that. We do have that. And that would be an applicable permit. We didn't have that. There would be an argument right there that Well, you can never start construction until you have that, the state of Indiana allow you to construct, but we have that. So I wanted to cross-examine Paul, if we can move to that.
Yeah.
Can you hear me and see me okay?
Sure.
Paul, can you hear me okay?
Yes, I can.
Okay. Paul, does the UDO say we need an ILP?
It talks about the commencement of the construction.
So point me to the UDO language that says an ILP is required.
I believe you're correct. It doesn't specifically say ILP.
Correct. The UDO, you said, is not discretionary.
That's correct.
So it's not discretionary. So you can't make up terms and conditions in the UDO that don't exist. Is that correct?
Sure.
And do you recognize that different types of development projects exist and they all don't need ILPs?
Yes, I do.
How many times have you had a multi-million-dollar, 100-acre solar facility come here to your jurisdiction and ask about what type of permits they are required to have? Now, let me rephrase, that was kind of convoluted. I apologize. How many times have you looked at a large solar project to make the determination as to what is necessary to commence construction? How many examples of that do you have?
At least two that I've sat in on conversations with over the last 5 or 6 years.
And in those conversations, how did you determine whether construction had started or not?
As neither of the projects had moved forward, it was moot.
That is correct. So this is the first time you're looking at a project, and for some reason, please explain to me why you believe the UDO requires an ILP.
I would say, based on redevelopment law, that initiation of construction would require an ILP.
And the ILP talks in the definitions, you will admit, about constructing or erecting structures, correct?
Yes.
So if a company commences construction, but they do not need to erect something immediately, but they've commenced construction in other ways, then they wouldn't need an ILP, correct?
I'm not sure what other ways they would initiate construction. The ILP is unique to our extraterritorial jurisdiction in corporate city limits.
Correct. Your UDO, though, does have another permit, a grading permit, correct?
That is correct.
So if all they needed to do was grade something, you wouldn't require an ILP. That would not be an applicable permit for commencement of construction, correct?
For grading, that's correct.
So how do you believe you have the authority then to make up what the UDO doesn't say? And that is that an applicable permit in this instance is an ILP.
I don't think I've made up anything. I think standard practice in the industry, if you look at what some of the state statutes say regarding the initiation of construction or redevelopment, make it pretty clear that I'm not making anything up.
And which states would that be?
State of Indiana, Indiana Code 6-12.1 when you get into the definition of redevelopment or rehabilitation activity.
Exactly. My point is that comes later in time during the construction cycle. The statute does not say, or the UDO does not say that we have to have the project, all the permits necessary to fully construct.
Is that a statement or a question?
I'm stating a fact. I didn't have a question.
Okay.
And I have no other further questions, except I have a comment and, a request to mention to the record my slides that I used today. I originally was just going to pass them out for everybody, but I think I should probably introduce them into the record as for evidence.
The objection, allow that as an exhibit, the petitioner's slide exhibit.
Petitioner's slide exhibit number 1.
Okay.
Do you have anything you want to add? Okay.
I don't want the BZA to be misled by mischaracterization of any testimony or any of the zoning codes, but I'd ask the Board of Zoning Appeals to look at City Exhibit 1. And this excerpts from the UDO. The very last page deals with requirements for solar energy standards for commercial solar energy systems. The very last page, the city administrator has entered into evidence, cites requirements, permits. An ILP is required prior to the construction, erection, placement, modification, or alteration of accessory solar energy systems. That is under the structure of standards for commercial solar energy systems. I just want to make sure the board is aware of that. I mean, I think your argument is that there is no requirement for an ILP, but the UDO does speak to that.
What is the UDO? I think I will object to any comment about what the UDO does and does not say from the council that's advising the BZA. At the same time, it's,
Well,
do you know what I'm saying? You're directing, you're directing.
I'll withdraw that comment. Please disregard it.
So I'm gonna finish my rebuttal now. You can address this question or this issue. Oh, sorry. I think
Hello, I'm Megan Lisberg. I'm a permitting project manager for Crossvine, and I actually live in Minnesota. Just to address the comment from the public that we haven't been in communication with the city. Crossvine did visit with Mr. Lake in August 2025. We had an informal phone call with him to see what the ILP application fee was and to make sure our development plan approval was in order. Mr. Lake was very helpful and very nice, and we had appreciated working with him. I don't remember his exact words, but the takeaway from that phone call was that no further action was needed for the development plan approval. At that time, he did not tell us that we needed to renew it, and we thought we were in order at that time. So
That was a miscommunication apparently. We visited with him as part of a larger meeting again in November 2025. And at that point, we visited with the city and Mr. Lake about our plan to submit the ILP at a later date after November 2025. And Mr. Lake's only request was that we apply for it before he went on leave in March. So that was the assumptions we are operating under. Thank you.
So you're the project engineer.
Permitting project manager.
Okay.
So,
So where's the project manager?
just someone who makes sure that,
Where is he? Huh?
oh, are you asking where
Yeah,
the
Are you
crossvine?
the project managers from the start to finish? From the time you came from the BZA and wanting a variance, you did all that?
Came to the meetings when
Okay.
We
Maybe
had,
we'll
sorry,
address
we
that
had a
little later.
community meeting with the city and Mr. Lake attended. I wasn't at that one personally. I can't say what was said there. I just saw the notes afterwards
Okay.
that we had told,
Sorry, were you referencing the November meeting that we have?
No, I'm talking about the July 12th meeting of 2023.
That was under the previous developer, so AES was still not on. Three companies ago.
Okay, that was under BP Sourcelight. So and you sold your operation to them?
No, we bought the project from them
Okay.
on April 2020.
Okay.
Sorry, May 2025.
Okay. So who was at that meeting? Who were the ones that came before the board or Mr. Lake and realized that they needed to come from the BZA? Was it you?
No, I mean,
That you needed a variance?
no, that was in 2023 before our administration, and that was under lights of
Okay.
so no one of the, and this team was involved in that process.
So, I was counsel for Crossvine Solar,
Okay.
at the time when we,
You came from this BZA board on.
yeah, when
July
we
12th?
we first came down, I think there was an issue about building and wetlands.
Yeah.
And we
So-
needed a variance. And the determination was that, we could not get that variance. It
Mhm.
was denied.
Mhm.
And so then the project was redesigned to avoid all wetlands. And we changed our plans for that and they were resubmitted.
Okay.
Or-
So whenever you determined that you needed a variance, exception variance, because of your building panels in a wetland, so
yes.
you were aware of that required under the UDO.
That, I don't know what the question is because it was denied.
Yeah,
We
but-
originally had a plan that showed construction in those areas
Okay.
and we asked for a variance
Yeah.
of that, which we can do. And you can get a
But what
variance.
stimulated you to ask for that variance? Where'd you get that information to ask for that variance?
I'm trying to recall, the best I recall was that somebody had looked at a problem,
UDO?
no, not a UDO, a map that showed where wetlands were located
Mhm.
and they saw where their panels were located. Maybe I'm misspeaking. Maybe you're asking a different question is how did we find out?
Yeah, how'd you find that out that you needed that?
Oh,
Um,
sorry. I
Okay.
misunderstood. I
That-
misunderstood.
Okay,
sorry. So I wasn't part of that project at that point, but I believe there's a floodplain overlay
yes,
district.
there is. But
Yep.
how did you find out that you needed that,
In the original
That-
application for,
that exception?
yep, in the original application that Light Source BP submitted, part of the application said that they would request a zoning variance
Okay,
and the approval was conditioned on them requesting that.
okay.
And since they did not get the variance, they removed that area from development. So the underlying development plan approval was still valid. They
Was
just didn't
denied,
get, they didn't get the approval to build within the
Right.
floodplain.
So when you went through this process of needing a exception for the panels in the flood zone, then as you're going through that, because you made a number of comments at how vague the UPO is, right? It's not precise, right?
In certain
Okay.
instances, that is.
So did you have access to the UPO back in September of 23?
I'm assuming so. yeah.
Yes, you did, didn't you? Yeah. Did you read that carefully and raise questions at that time about the vagueness of the UPO? When did this come to surface to where now the vagueness is coming up when it didn't come up in September 12th, I'm on that board, in 2023? Did that come up now when all of a sudden, when this appeal happened? Is that when you all of a sudden start looking at it a little more closely?
Those are different areas of the UDO.
You see what I'm getting? Why, how did we get here?
I don't
Had that
understand.
information a long time ago, correct?
Yeah, I don't know what we're
So
talking about.
why didn't you review it and question the vagueness of it at that time? Why did you wait until now?
We're talking about two different areas of the UDO.
Well, let's look at the
Oh.
UDO as a complete statute. Okay?
Okay.
So now all of a sudden we got to this point and now you're questioning the UDO, right?
Yes, a section of the UDO.
Why didn't you question it back in July 12th when you came from my board and wanted a variance or an exception?
I don't understand what you're asking.
Okay?
These
Why'd
are
you
these are
pick out
different.
just that item and you didn't realize that there's some other issues in the UDO that may be vague or not complete, according to your opinion, okay, or misunderstood? Why didn't that come out way back then and now it's coming out way down here in this process? And maybe I shouldn't be asking this question.
We're not talking today about any of those provisions that were discussed back then. Those are different provisions.
Yeah, but that's how we got here, right?
No, that's not how we got here.
Because you didn't, that was never a question. If you would have raised those questions up before with Mr. Lake, then maybe we would have had an ILP, okay, back then, or you would have addressed that issue back then, or you would have understood what commences as starting of construction. See what I'm trying to make here? Why is that now coming up as an issue when you read the UPO before, didn't? You never looked at that.
It came up as an issue because a letter was directed to us that said we needed an ILP because we haven't constructed.
When
And
did you know you need an ILP?
when did I know that I need, we always have needed one. It's just not yet.
Okay.
We definitely, there's no question that we need an ILP.
Yeah.
And, you know, if you want to rule that tonight, that, you know, we will allow you, we will have Paul resend this letter. Okay. We think you've done enough to commence construction, but you got to get that ILP, and I want it on my desk in 30 days, or we're pulling this from you. Then the board can do that.
I understand.
And we will submit that ILP in 30 days.
Okay.
Okay, we definitely.
I'm just
Okay.
trying to understand how we got here,
Yeah,
how we got to this point.
sure.
What could have been done to understand the UPO and the vagueness, according to you, or the misunderstanding, according to you, or incompleteness, and how we got to this point?
Yes, I appreciate that.
Okay,
Thank
how
you.
did we get here?
Yeah.
Okay,
Thank
thank you. Maybe I shouldn't ask that.
Well, my thing is with the UDO is that you obviously read the UDO to knew you need that variance. If there was any vagueness, why wasn't those questions asked, before we got to this point, I guess it's more or less.
So we're here not to use go back too much into history of that, but you're investing, you said $300 million on this thing. Okay, so if I'm gonna invest that kind of money, I'm gonna make sure that I get all my, leads up front and see what I need.
Your
But
ducks in a row.
it is not, discussing every single detail on that, but okay, what do I need to start and what do I need to get it? Now you acquired this from another company. That company should have given you all that information up front to start all this. Now we are here representing our town or city, and we are taking our decisions according to what our city needs, or not affecting or also our fellow citizens. So the BCA has a good leader with Paul, very professional. Okay, well, we've been here several years with him, and it's like the comments that you had as far as the process that we take to make a decision or approving or disapproving. He is our leader, but it's up to us to decide whether it is good for us as a city, as a citizens, or it's not. So yeah, there is a lot of stuff in there, but yeah, you guys went over the your stay limit of 2 years to begin construction, and it didn't happen. So, you know, there's really nothing to go past that on that, you know, with all this.
Could I just, before you guys deliberate, maybe offer just a little bit of cross rebuttal and then we'll just.
Right.
Sure.
First, I want the record to reflect that Mr. Schneider promised me pizza and beer if this went after 7, and that is not here.
Buy it.
So I object to that. Don't see one. But a couple points here. Since there were some allegations made about Mr. Lake's comments and how he handled things, I just want to get on the record. Mr. Lake, did you at any time waive any of the UDO requirements in your
No,
discussions with Crossvine representatives?
I do not have the authority to waive any of the ordinance.
Okay, so that is a no.
Correct.
At any point, did you receive or were you aware of, or did you look for an IDEM permit that was applied for or obtained by Crossvine?
I had been contacted from the Department of Natural Resources 2 or 3 months ago asking if anything was occurring within the floodplain within our jurisdiction, at which time I informed them that no, there was not.
Okay. So is it your understanding that Crossvine would need an IDEM permit?
I would believe they would, yes.
Okay. All right, members of the board, just real quick. I mean, there's been a lot of discussion about the ILP, whether it was obtained. First, I want to point out that if you take the city exhibit number 1 and go to the last page, there's a highlighted provision there that says an ILP is required prior to the construction of a solar energy system. Prior to the construction. There's been no ILP. So on the one hand, Crossvine is trying to say they've commenced construction, but didn't get an ILP because they didn't need one. So no matter how you look at it, they're not following the UDO. They violated it. It's not there. But under the terms of the UDO, they did not apply for, they have not obtained the ILP within the 2-year period. For all the reasons I discussed necessary, it was necessary. It was certainly necessary before construction began. Construction, either hasn't begun and therefore they missed the 2-year window, or it has begun and they didn't get the ILP as it was required. Either way, they didn't do it right. What was required under the UDO was you get the ILP and you commence construction all within the 2-year period. That's what's required there. That wasn't done. On the second point, and just finally, the suggestion that Mr. Lake waived something, this is a he said, she said thing. He says he didn't, she says she did. It doesn't really matter whether he did or didn't. He didn't have the authority to do that. What the ordinance is what the ordinance is. Some administrator or employee of the city doesn't have the authority to void duly enacted city laws. Again, you have plenty of reasons to deny this request. Construction was not commenced in time, the applicable permits were not obtained, and you have a city moratorium in effect.
Does the board members have any questions of either the petitioner or the city administrator? At this point, statutorily, the BZA is required to make a decision, and if to deliberate and make a decision on the evidence presented. If you're unable to, you may, at the conclusion of the evidence, you're required to make a decision, unless you continue the hearing and decide at a different date. What typically happens is that if you're prepared to make a decision, you can make a decision tonight, but that decision ultimately needs to be supported by findings, which can be adopted at a later meeting. Both parties could submit proposed findings and you could adopt those later. But the one decision you should make tonight is whether to affirm Mr. Lake's decision with regard to those two issues, or whether you should reverse it. If you don't feel like you can make that decision tonight because of the evidence that you need more time, then you need to continue the hearing to another date. I do have just a template for an order, and I'll pass those along. You certainly don't have to use this. I guess, not boring you, I think I need to just read it. This matter comes before the City of Huntingburg Board of Zoning Appeals on the appeal of Crossvine Solar One LLC of the zoning administrator's December 2, 2025 order revoking the approval of the petitioner's commercial solar energy system development plan and implementing a legislative moratorium on consideration of any new, revised, or resubmitted development plans for commercial solar energy systems passed by the City of Huntingburg Common Council. Due notice of the date, time, and place of the hearing was published and given as required by law. The petitioner appellant appeared by counsel Douglas Everett and by representatives. The zoning administrator, Paul Lake, appeared in person and by counsel Joshua Claiborne. Evidence and testimony was presented by the parties, and an opportunity for public testimony was afforded to interested persons. After considering all the evidence and testimony presented, the City of Huntingburg Board of Zoning Appeals now finds and orders as follows. Number one, the zoning administrator's December 2, 2025 order determining that the August 7, 2023 approval of the petitioner's commercial solar energy system development plan became void for failure to obtain all applicable permits and to commence construction within the 2 years of approval as required by Chapter 8D2 of the Huntingburg Unified Development Ordinance. It is hereby, and you can select affirmed or reverse. The next finding is without ruling on the constitutional validity of the moratorium, a matter reserved for judicial review, the zoning administrator's December 2, 2025 determination declining to accept new, revised, or resubmitted commercial solar energy development plans in compliance with the November 25, 2025 legislative directive of the Common Council is hereby either affirm it, that he did the right thing, or reverse it, that he did the wrong thing. And then there is a place for each of you to vote on that. You can rule in the alternative on either one of those. They don't have to both be affirmed or reversed. One could be affirmed, one could be reversed. But you can begin your deliberations, and I'm here for questions, try to answer questions. And if you have questions of the presenters of either party, they're here as well.
I would say affirm them both, but based on they say construction's commenced. I mean, it's either they said UDO is vague, but they can't be vague on construction.
First of all, this issue here is another issue that is in the fighting, but not meeting a timeline. This denial could stand just on that.
Usable, yeah.
So then we got
That
this
is no
as well.
Yeah.
Just not on that.
Yeah. So we go on. This say it will both ways.
Somebody have to make a motion or whatever.
We didn't make a motion, or we just have, or just assign our vote.
Well, I think you've got, since there were two issues presented, I think you need to perhaps a motion on each of those issues.
First voting on them, second.
Now, to make it clear, if you affirm, please, some decorum. If you affirm, that means you're voting in favor of the decisions that Paul made. If you reverse, then you're instructing him that he was wrong and did not follow the UDO or applicable law. So I think if you're wanting to consider that tonight, I think you should take each one separately and vote on each one separately, and then record your vote on the order.
So we'll have,
We'll go ahead and You guys
Okay,
comfortable
so-
going in and voting tonight or?
Yeah.
Okay.
I think so. If you feel like everything's complete, yes.
Okay, so do you have a motion to affirm
I
the,
object. Um, they're voting on something, but they have not discussed, and I haven't heard anything about findings of fact. What is the basis for the determination for the vote tonight? They want to vote tonight and then later, in time, come up with the reasons for their vote. They need to have, they just can't copy this and say, we find, that they've constructed and say, you have to have reasons on the record as to what their vote is. Why is each of them voting a certain way?
So we already have enough reasons listening to your proposal and what we have read, okay?
Yes, but each
So-
person
Mr.
has
President, I
to-
would say that the proposed order here has reasons, and if the board wants to make those their reasons, they can. If Crossvine has a problem with those reasons, they can appeal it to the court. It's very simple. But I mean, I
This
see
is our
here-
decision as a board to do that.
Yeah,
Okay,
I mean,
and
we've
we're
got
gonna do
failure
that.
to obtain all
So
performance
first
and to
order.
commence construction is one option.
To say it out loud so everybody hears.
Reverse or
First
affirm
order.
that, or the moratorium, you can affirm and reverse it there. The
Stay away
three
from
reasons we
moratorium.
talked about all evening are there. You can either affirm their appeal, affirm the denial or reverse it. Real simple. The reasons are there. They can adopt, and it's very normal, it's common. If the board wants to adopt further, more detailed findings of fact after this, they can. That is certainly the norm I've seen, but I think that this particular order has more than sufficient to meet its burden tonight.
The petitioner's objection, of course, is noted on the record. It's up to the board how they want to proceed.
we're gonna use these?
Yeah.
Okay.
So we affirm.
Do we have a,
I affirm the first order.
do we have a second?
I'll second it.
All in favor?
Aye.
All opposed? To the,
Second.
now the moratorium, or
Second order.
do we have a,
Good motion.
we have a motion, I'm sorry.
Go ahead.
I have a motion for,
I'll second the motion.
I'll second. Would you second?
All in favor, of
Aye.
affirming, aye,
Aye.
all opposed?
so now read that in today's date.
I've got the original here.
Read it out loud. It's included with the dates today. And then sign it. Read it out loud.
What do you?
So I-
Read all this loud.
I'm just going to pass this around.
We'll
If
sign
you
it.
would check mark, if you voted aye, check mark aye and sign your name next to it.
Okay. We got a pen.
I'm sorry, the vote was to affirm Mr. Lake's decision in both issues, on both issues.
You read it, shake it.
Wait, should I go ahead and read that then, or,
I'm sorry.
No, you fill this one up.
okay,
You can read it loud. I would say on this day, we'll do that. And that's it.
okay, after we sign it. Okay.
Two of them signed.
This one.
Just one.
So you can read it loud to everybody and you can. And then we'll adjourn the meeting after.
Should we mark that, right? Supposed to be, okay. Yeah,
All
okay,
right, 'cause
yeah,
we
yeah,
voted to
okay,
affirm.
Okay,
So.
I'm gonna use the other way.
So ordered this 11th day of March, 2026 by the following vote. We all voted in favor of affirming all X findings. I don't think there's,
So both motions are firm as being approved for City of Hindenburg not denied the request, so.
Yeah.
Now we have to make a motion to adjourn.
Motion to adjourn.
Yeah, can I have that for the record with the?
Make a motion to adjourn the meeting.
So, make a motion to adjourn. Sorry,
I'll make the motion.
A second. it.
all in favor of adjourning the meeting?
Aye.
Say Aye. Aye. All opposed? Meeting adjourned.
Please adjourn.
Thank you.
Thank you guys for coming.
Oh, that's mine, I think.
Oh, that was.
Oh, is that yours? Okay. I got so much crap here. I'm swimming in copies.
I know.
I don't know. This is, oh, this is, I don't know if this is yours or mine.
I want to keep copies of this for a while.
Is this record till I shut this down? So still online, so I shut it down.